Of temporary restraining orders limiting the ability of immigration agents to detain people based merely on their race and ethnicity. Also requires detainees be given access to legal counsel.
Now let's bring in Jessica Levinson. She's a law professor from Loyola Marymount University. Good to have you, Professor. This doesn't necessarily stop the raids from happening, the raids like we've seen in recent days, the one at MacArthur Park and the cannabis farm in Camarillo and Carpinteria, or does it?
This is about how, not whether, to enforce federal immigration law. So I think you're exactly right to point out that this is not a judge saying there's a temporary restraining order on enforcing federal immigration law. There's a temporary restraining order on how ICE agents are enforcing that law, and specifically what they can and can't do. And really what I think the decision boils down to, and again, a temporary decision, is that ICE agents need to demonstrate that they have a reasonable suspicion that people are violating federal immigration law, and that that reasonable suspicion isn't based only on the color of someone's skin, the language that they're speaking, and where they are, for instance, if they're outside of a car wash.
All right, so we know that the Trump administration tends to then file appeals on these rulings. Do you expect that? And what does this mean for the rest of the country right now?
Great question. So this is a temporary restraining order, and typically speaking, those are not appealable orders. So what it looks like right now is that the parties are looking forward to the next step, which is a preliminary injunction. And that, just as the name indicates, is a question about whether or not this temporary restraining order will be in place for a longer period of time. At that point, the loser can decide whether or not to appeal up to the Ninth Circuit. And because this is a decision based on the Constitution, obviously, if there are other suits in other jurisdictions, I think they would look to this decision, but it's not binding on them. Certainly, it would be persuasive.
So we do or do not know how long this will last then?
So temporary restraining orders are typically about 10 days. I'm being very general here,
okay,
but we're going to have a hearing, I think, quickly on that next question.
Okay, and then for those detainees that are currently being held, this impacts them as well?
That's right. So the judge said there were 2 temporary restraining orders, and what the judge said is that for those who are currently detained, that they essentially need to be granted access to legal counsel and needed to be granted access to additional information. So it's both forward-looking and, in a sense, backward-looking to those who have already been detained and what rights and access they have the ability to obtain.
So quickly, do all these actions really happen?
That is something that I wish I had a crystal ball. I mean, the question in itself is important because we know the Trump administration has felt that sometimes judicial decisions are just incorrect and have had a variety of different reactions to those decisions. An appeal is different from ignoring a decision. So we need to see what happens in the next few hours and days.
Okay. All right, Jessica Levinson, thank you so much always for your expertise.
Thank you. In the meantime, we have this reaction from LA Mayor Karen Bass. She weighed in on the ruling, saying, in part, this is an important step toward restoring safety, security, and defending the rights of all Angelenos. We went to court against the administration because we will never accept these outrageous and un-American acts as normal.
Southern California immigration crackdown halted. What it means for Trump's policies. A federal judge on Friday found that the Department of Homeland Security has been making stops and arrests in Los Angeles immigration raids without probable cause and ordered the department to stop detaining individuals based solely on race, spoken language, or occupation. U.S. District Judge Yusi Mensah Frimpong, an appointee of former President Joe Biden, ordered that DHS must develop guidance for officers to determine reasonable suspicion outside of the apparent race or ethnicity of a person, the language they speak or their accent, presence at a particular location such as a bus stop or as the type of work one does. Friday's ruling comes after the ACLU of Southern California brought a case against the Trump administration last week on behalf of 5 people and immigration advocacy groups, alleging that DHS, which oversees immigration and customs enforcement, has made unconstitutional arrests and prevented detainees access to attorneys. The ruling is limited to the 7-county jurisdiction of the U.S. Central District of California, which includes Los Angeles and surrounding areas. Frimpong said in her ruling that the court needed to decide whether the plaintiffs could prove that the Trump administration is indeed conducting roving patrols without reasonable suspicion and denying access to lawyers. This court decides based on all the evidence presented that they are, Frimpong wrote. Frimpong went on to say that the administration failed to provide information about the basis on which they made the arrests. The temporary restraining order also applies to the FBI and the Justice Department, which were also listed as defendants in the lawsuit and have been involved in immigration enforcement. In Friday's ruling, Frimpong also ordered DHS to maintain and provide regular documentation of arrests to plaintiffs' counsel. In a hearing Thursday before she ruled, Frimpong appeared skeptical of the government's arguments. The government said in court that DHS agents initiate stops based on intelligence or trend analysis, not on race or ethnicity. Frimpong repeatedly pressed the government to provide evidence that arrests were based on actionable intelligence rather than targeting areas where undocumented immigrants are presumed to gather. It's hard for the court to believe you couldn't find one case with a report of why someone was targeted, she said Thursday. In a separate temporary restraining order, Frimpong blocked DHS from denying the detainees access to counsel, including visits and calls, in a holding facility until as B18 in court documents. Immigration advocacy groups had raised concerns that detainees in B18 weren't afforded the opportunity to contact a lawyer. They also claimed that the detainees were held in inhumane conditions, such as not having access to beds, showers, or medical facilities. DHS spokesperson Tricia McLaughlin condemned the ruling in a statement, saying, "A district judge is undermining the will of the American people." Since returning to the White House, President Donald Trump has moved aggressively to crack down on immigration. Last month, the Trump administration called for ICE to expand deportation efforts in Democratic cities and do all in their power to achieve mass deportations. Trump also ordered the deployment of thousands of National Guard troops to Los Angeles last month in response to protests against his administration's immigration raids. The administration previously sued the city of Los Angeles over its so-called sanctuary city policy. California Gov. Gavin Newsom, a Democrat, celebrated Friday's ruling in a post on X, saying, "California stands with the law and the Constitution, and I call on the Trump administration to do the same." Similarly, Los Angeles Mayor Karen Bass hailed the ruling as an important step toward restoring safety, security, and defending the rights of all Angelenos. Mohammed Tajsa, senior staff attorney for ACLU of Southern California, said in a statement, "No matter the color of their skin, what language they speak, or where they work, everyone is guaranteed constitutional rights to protect them from unlawful stops." Like and subscribe for more. Thanks.